Well, hello to all. This is Sebastian Mallet, Professor of Law and Legal Studies at the University of Carleton. I wish to create that little video, and my daughter is not far from me in the office today, so I apologize if you hear back noise. But some people have asked me to come up with a little video to perhaps explain the Daniels case, and it makes my daughter laugh a lot when I'm speaking in English, as our first language at home is still French. But anyways, so yeah, a little video to help the people navigate just a bit about that very important case that did happen April 14, 2016 at the Supreme Court of Canada. Case brought forward initially in 1999, if my memory is correct, with Harry Daniels leading the way again for the Métis peoples of Canada, and to make sure that Métis people could get a sense of justice. And so I'm going to come up to that details in a few seconds. So I have a bunch of documents with me to help people navigate a little bit with that case from an oral perspective. Many people out in the communities perhaps don't have the resources and the ways in which to read all that document and to make sense of it. There is also sour people about that judgment, and people that profess this idea that the Métis Nation of the Northwest has been cheated out of that decision. And I'm going to come out to that in a second. So first and foremost, I want to salute the courage of Gabrielle Daniels that I saw at the Supreme Court. We arrived at the same time that morning, and so it was a very incredible morning. A lot of people were there, a lot of different Métis communities and nations, I would have to say, were there. People from the settlement, Métis settlement, were there. Different groups, different people, non-status Indians, communities and groups as well. So it was a very important case for a lot of people, and I wanted to say that up front. I cannot understand why some people are putting down the effort of so many people over 14 years to seek clarity and justice on those questions. Most especially that clarity and clarifications on these very important matters, which are at the heart of the Constitution of 1867, which means the foundation of Canada, are really important. Clarification is the first stone you have when you go negotiate with the government. So in that regard, this is truly important. Now about the details of that decision, if I may. I'm just going to read the first paragraph for you to understand. First paragraph of the decision of the Supreme Court, paragraph 1. As the curtain opens wider and wider on the history of Canada's relationship with its Indigenous peoples, iniquities are increasingly revealed and remedies urgently sought. Many revelations have resulted in good faith policy and legislative responses, but the list of disadvantages remains robust. This case represents another chapter in the pursuit of reconciliation and redress in that relationship. So needless to say that the intent of reconciliation and the acknowledgements of injustice and wrong treatments of the Indigenous people of Canada is acknowledged in paragraph 1 by the Supreme Court of Canada, which in and of itself is a huge historical gain when you think about it. Now, 3 declarations were sought into that case, which I'm going to state for you. The first declaration sought that Métis and non-status Indians are Indians, between brackets, pursuant to Section 9124 of the Constitution Act 1867, which means the section 91 and 92 that distribute federal versus provincial area of jurisdictions. And why does this matter? Well, because there has been historical ping pong game with the Métis and the non-status people between provincial and federal government. We know also that various ping pong games between provincial and federal crowns have been affecting the indigenous people of this country since a very long time now. So that was the first SALT declaration. The second declaration is that the federal crown owns a fiduciary duty to Métis and non-status Indians. Second declaration, fiduciary duty. And then the third one, that Métis and non-status Indians have the right to consultation and negotiation. So, fiduciary duty, the second one, and a right of consultation and negotiations, the third one. Now, some people suggest that these two last declarations sought were denied. I have to answer, in my opinion, yes and no. As we will see in a moment, these declarations are already matters of settled law, which means that we already have court case that spells out the legal avenues for the Indigenous people of Canada to go on with a challenge for lack of consultation. If we think of IDA, for example. And the other one is the fiduciary duty, which has to be again challenged in particular. And we already have settled laws to deal with this. So it's not that they were rejected backhand, but that they are already matters of law, and it would have been redundant for the court to say otherwise. In addition, the courts in Canada do need practical case by case trials to decide over these issues when subject are brought before the court, so to speak. So it was a unanimous decision, which is an important detail as well, written by Justice Abela of the Supreme Court of Canada. And an important point is that that decision to make now the federal crown or the federal government responsible in terms of fiduciary relationship of all Métis peoples across Canada, as well as the non-status Indians, so to speak. Well, that doesn't make the provincial legislation for Métis settlement, for example, or for other deal that has been, going on with provincial government, ultra vires, which means that it is not because the federal is now in charge that all the deal passed with different province is off the table. Obviously not, says the Supreme Court of Canada. So I hope this brings a little bit of clarity to it. And, I want to mention another very important point that a lot of communities had in their preoccupations, especially when I've traveled to eastern communities, but also northern communities, and frankly, all communities across Canada. As we know, the famous Pauli test that comes from the decision Pauli regarding the Métis in 2003 has been problematic for a number of communities, including communities out west. And I'll be honest, in Heresecorn, which is a court case you can Google, the Western Métis community were not successful in securing the Paoli test. Yet in the north, you know, community of Great Slave Lake, the Métis community there that have an independent ethnogenesis, if you allow that expression, or an independent rooting in their people, but are nevertheless Métis, did win a Paoli case under the famous court case now, NJ, in 2013, which you can also Google for your reference. So right off the bat, in law, Canada is already recognizing the existence of diverse Métis nations by these court cases. And not only do Canada recognize it, but it recognizes it on the voices of the people that comes forward with those claims. So it's not like we don't have to go all colonial on this, suggesting that Canada is now interfering with the business of the Métis. It's the Métis themselves that are coming forward with the fact that they are independent and different communities or nations with their specific interest, geography, relationship with other indigenous people around, kinship system, and traditions. So a very important point, I'm going back to the Paoli test, we have to look at the history of the case a bit. And the history of the case Paoli. You okay, daughter? Fais-moi une fois un peu, s'il te plaît, mon amour, okay? Je t'aime. So, going back to Paoli, and sorry for the disturbance here, my daughter is trying to draw a picture for us for that wonderful day. So going back to Paoli, we have to look at the history of the previous decision. The trial decision under Justice Phelan stated that in terms of Métis identities, if I remember correctly, that Métis people and non-status Indians have both in common the fact that they cherish their Indianness. Now, a lot of people went crazy with this. What is this Indianness thing? We're Métis people. We have Métis ancestors, and so on, right? And so, intervention were made part by Métis National Council to suggest that their nationalistic definition of Western Métis only per the Nation of Red River were to be accepted as the only Métis out there. And so that created a huge rift in different Métis communities that I've traveled to and visited. A lot of people got really nervous. And rightfully so, because the appeal on that decision suddenly reintroduced it Paoli right into Daniels, suggesting that Métis ought to be defined by proof of an historical community. Now, I'm not going to get into a debate about what is a community. Even the Supreme Court of Canada in Paoli refused to define clearly what was a community. Nor am I going to get into debate about what constitute the Métis nations. I have my own views on what is the Métis nation per Louis Riel philosophy, which, per records and facts, was an inclusive ID for all the Métis people across the land. That being said, now the Paoli got reintroduced into that decision, and it got a lot of people nervous for a specific reason. And I will highlight one or two reasons for you as I'm going casually into this. The first is that, as I said, many people can have trouble making the Paoli cut, so to speak, including in the case of Hirsukorn. And when that happened, well, guess what? The government is usually saying to you, you didn't secure that Paoli court case, bye-bye. So that was a huge problem. Another problem is that we know that some organizations out there are negotiating with the government to create a new Métis registry that would be based on Paoli criteria, like a new Indian list that would work for the government, and they would be the gatekeeper of that organization. Well, that created a lot of problems for different independent Métis communities across the country that have their own views on their identities, their own form of governance, their own form of management, their own concerns. They said they're going to create now a list and specific cards that will go above and beyond specific concerns of Métis communities dispersed across the land. So this is not right. So a lot of people got nervous with the Paoli. Hence, when the appeal was made for that decision, Daniels, to go in the Supreme Court, a lot of parties started to intervene, including the Alberta Settlement, different groups, and, in part, the Métis Federation of Canada, whom I have been an advisor for that case, with the firm Devlin, Gaylis, and Westaways that worked with us on that case, to clearly show in our memorandum, our document brought forward to the Supreme Court with all the help of 13 different Métis communities across the country that volunteered their own time from a grassroots perspective, selling artifacts that they had in their family for one shot to defend their rights in front of the Supreme Court. This is not to be put down, in my opinion. So all these communities and Métis peoples across the country, including in the eastern part of Canada, but also elsewhere, back it up by this very amazing law firm, Devlin, Gaylis, and Westaways, very professional law firm, helped it to show that in fact Section 9124 of the Constitution of 1867, which is at the heart of this case, is doing a very different job. It's to do a different job than Paoli, which is mainly a ruling in an harvesting case, mainly in relationship with Section 35 of the Constitution of 1982. Well, Section 9124, to avoid any confusions that some people may have, is, as the decision is stating clearly, about the protective power that Ottawa owns to all Indigenous people of Canada. It is what we call a fiduciary relationship. And by that relationship, it has obligations. And when there's a breach of these obligations and duties, then it is to the parties involved to make their case, to negotiate, or at last resort, sadly, to bring it to Canadian courts for a settlement. So this is really important for us in terms of decision, because the Supreme Court of Canada stated that Paoli, and most especially the community acceptance criteria, by which so much of what we know about the dirty politics can be played in terms of acceptance and rejectal, leaving individuals out there in the cold sometimes. So this has been, isolated in the decision. The Supreme Court stated that per Section 9124, Paoli doesn't have to be enforced. That the fiduciary relationships of the Government of Canada that it homes to all non-status Indians and Métis peoples of Canada doesn't have to be restricted by Paoli views. Not only Paoli views, but truly what are Paoli restrictive interpretations that we are seeing being played in court right now. If we go per the factum of the Paoli case itself, we can see a lot of amazing things and a very flexible approach to Métis communities that are sadly not reflected in some of the latest decisions we've seen in different trial courts and above. That being set aside as a comment, let me conclude by one of our last points, also truly important for all the Métis people that put their efforts in terms of interventions at their own cost, efforts, and time. Also in line with the memory of Harry Daniels that stated in 1994 that in fact Métis, per the Constitution of 1982, that goes back to that famous Section 35.2, that Harry Daniels himself negotiated with Chrétien Trudeau, the father. He said that they understood at that time that Métis was from coast to coast to coast, with no geographic or chauvinistic or regionalist limitations. This is recorded in the report RCAP, as we call it, published in 1996. So Harry Daniels had a very strong philosophy about that in the report Commissions of Aboriginal People. And so did Riel, who openly stated in 1885 that eastern provinces of Canada included a number of Métis peoples with similar right than those of the northwestern prairies, which means that the distinction for him was clear, and that these people were not just a subject of mixing, but right holders in the eyes of Riel. Now we can blame Riel for a lot of stuff, but surely we cannot blame Riel and Harry Daniels and countless other leaders of misunderstanding what Métis culture is all about, including the fact that we do understand generously through the networks of histories and different cultural modulations that Métis took different forms and expressions as it went. Hopefully that point will be clear for some people out there that sadly still use divisions, fear, and greed, most likely, to divide the Métis peoples into interests that would be irreconcilable. But here, the Supreme Court of Canada, on April 14, 2016, stated a very clear message. Not because it is a boogeyman of colonialisms necessarily, but because it was in front of facts. And I encourage everybody to read the reports of Jones, for example, on these facts from the trial decision, and also the trial decision, and also all the testimonies from communities, from people, from Métis, from non-status, that stated clearly that different Métis people existed around Canada. So it is by facing those facts that the Supreme Court came to the conclusion that there is many Métis peoples in Canada, including most clearly in the eastern regions of Canada under paragraph 17 of the decision that you can find online. Now I'm going to take a special moment to read you that paragraph, section 17. The decision has 58 paragraphs, if I remember correctly. So paragraph 17 goes like this. For the people that may have trouble reading, or for people in the communities that might have problems with their, poor eyesights when we grow older and are not provided all the services that we deserve. So paragraph 17, I'm stating, there is no consensus on who is considered Métis or a non-status Indian, nor need there be. Cultural and ethnic labels do not lend themselves to neat boundaries. Métis can refer to the historical Métis community in Manitoba's Red River settlement, or it can be used as a general term for anyone with mixed European and Aboriginal heritage. Some mixed ancestry communities identifies as Métis, others as Indian. There is a quote added to that. There is no one exclusive Métis people in Canada, any more that there's no one exclusive Indian people in Canada. The Métis of Eastern Canada and Northern Canada are as distinct from Red River Métis as any two peoples can be. As early as 1650, a distinct Métis community developed in La Heve, Nova Scotia, separate from Acadians and Mi'kmaq Indians. All Métis are Aboriginal people, all have Indian ancestry. End of quote. This is from Gaffney, Gould, and Semple, Broken Promises, the Aboriginal Constitutional Conference, 1984, at page 62. Quoted in Catherine Bell, Who Are the Métis People in section 35.2, 1991, 29, Alta Law Review, I'm guessing, 351 at page 356 for future reference. You can find that at the page 8 of the judgment, paragraph 17. So here it is clear that the Métis people in eastern of Canada have been identified under a decision, one of the most important decisions, Supreme Court, in regards to Métis people and their place within Section 9124 of the Constitution of 1867. I already did a conference you may find online where I reviewed a number of historical evidence that these people in La Heve were described historically in the 17th and 18th century as Métis, as Bois Brûlés. I have found articles of journals in Quebec that describe the Acadiens Métis in 1886 as forming communities with leaders. I mean, there's a lot of evidence out there for those who wish to see. Yet there's still denial out there. There's still fear that as other community thrives and re-emerge after centuries of colonialisms in attempt to extinguish them, that's going to somehow affect the interest of people 3,000 kilometers away from them with their own histories, such as the beautiful history of Red River. And I take this moment to salute all the people and friends I have in Saint Boniface, Winnipeg. brilliant, vibrant communities of Métis there I had the chance to visit. So also for the people of Red River, per the excellent work of Jonesboro, there's also a very important statement for you guys, in where it is recognized that you guys had a legal presence, Métis legal presence, at paragraph 26, stated from the work of Professor John Burroughs. So it appears that this is a very important statement. Why? Because this recognizes your society and its legal abilities. And this, I believe, is just a very good news as well. So if we can stop these divisions among Métis peoples and recognize that this decision was important in many respects, as opening a door for negotiations to happen, for self-determination to occur, for Métis communities across the country to self-determine their identity, their project, their vision, their future, in collaboration with First Nations and Inuit peoples of Canada, in creative ways. If we get to that point, true, the clarifications brought by this very important decision is crucial for us to open those pathways. It is certainly not the end, but it is truly a magnificent and promising future. My daughter is wrestling with her drawing. Callie, you want to show? Tu veux-tu montrer le dessin à le monde? Viens montrer. Viens, prends ton dessin, viens montrer. Okay, viens le montrer. It's her special day today. There we go, little drawing. All right. Well, thank you. J'ai fini en 2 secondes, amour. Ouais.
C'est parce que ça défait tout ça.
C'est correct. Je vais t'aider dans 2 secondes. So anyways, I hope you did appreciate that casual talk about that case and the concerns of so many. Here it's family day in the office. If it's not serious enough for some people, I can recreate it under another format. But at the very least, here from Ottawa, I hope that this message is reaching many communities up north and different locations to say that we can all coexist. And I believe that the basis of that decision is that we can bring forward our own negotiations without any top-down approach, or people coming over our heads telling us that we're not good enough, that we're not national enough, that we didn't have true politics back in the days, and that if we're not Red River Métis, then we're necessarily racist. It's time that we stop those strange comments and that we move forward into reconciliation among the Métis peoples, first and foremost. So thank you very much for listening, and if you have other questions, you can always reach me. Again, my name is Sébastien Mallette, Professor of Law and Legal Studies at Carleton University. Thank you so much for listening in, and talk to you soon. Bye-bye.